aspect of the defense for the penalty phase. So I believe would be not only irrelevant, unduly prejudicial, and it's hearsay.
We're in the penalty phase, so that the hearsay rules get relaxed.
I'm sorry, I don't mean to cut you off.
Go ahead.
But yes, under the case law, if hearsay is permitted, as long as the defendant's constitutional rights for confrontation are not violated. There's no way we can cross-examine, unfortunately, Ms. Colley because of that statement. So it's really a backdoor hearsay approach. It's not, I'm not saying that in a heinous way or anything like that, but it is what it is. It'd be like any other type of statement written by somebody else. It is hearsay, and there's no way we can confront that. It's a violation of his U.S. constitutional confrontation rights as well as Florida constitutional rights.
This was just allegedly a comment of a threat to harm the animal as opposed to an actual act against an animal.
That's my understanding, Judge.
Okay, I'm not going to allow the testimony.
Okay, thank you, Judge.
Okay. Everybody else, everybody ready? That was going to bring the jury in. Everybody very much. And we are ready to proceed. Now, Mr. Wood, do you have any further witnesses?
No, Judge, we rest.
All right, ladies and gentlemen, the verdict defense just rested. In this case, the state has an opportunity to present rebuttal evidence if it so desires. So does the state move forward with rebuttal evidence?
We do, Your Honor, and the state would call Dr. Jeffrey Danzinger.
Dr. Danzinger, you'll go to stand right here, remain standing.
Do you solemnly swear or affirm the testimony about the truth, the whole truth, and nothing but the truth?
Good afternoon, Your Honor. Good afternoon. You can be seated. Mr. Johnson, you may proceed when you're ready.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon, Mr.
Could you introduce yourself to the jury?
My name is Jeffrey Danzinger, and I am a psychiatrist in Maitland, Florida, just outside of Orlando.
And Doctor, just for the benefit of you spell your last name.
It's Danziger.
And you believe you indicated that you are practice as a psychiatrist, is that correct?
Yes.
And can you kind of outline the nature of your work that you do as a psychiatrist?
Over the past years, I've done several things as a psychiatrist, which is a medical doctor. I treat patients. I saw patients in the office yesterday. I'll see people in the office tomorrow. And it's a general psychiatric practice. People who suffer from depression, anxiety, bipolar disorder, schizophrenia, panic disorder. I'm a treating doctor to them. Also, over the years, I've been involved in many drug studies where I'm the principal investigator, and oftentimes these are medications not yet on the market to treat depression, schizophrenia, or bipolar, or they're medicines already out on the market, but for a new purpose. And the third hat that I wear is what I'm doing today as a forensic psychiatrist. So I'm not in a treatment role today, but I'm taking medical and scientific information and offering opinions about somebody's mental state here in court to juries, judges, and lawyers. So essentially, I wear three hats as a psychiatrist, and today I'm here as a forensic, not a treating doctor.
And you indicated that you're a medical doctor, correct?
Yes.
And you're, what, are you licensed in a particular state or states?
Yes, I'm only licensed in the state of Florida, my native state.
Okay. And how long have you been working as a psychiatrist?
Well, I started my internship and residency in 1982 after graduating medical school, so by that standard it's been 38 years. If you do it for when I finished my training in 1986, it would be 32 years, so a long time.
And you kind of got into it just a little bit there, but can you maybe a little bit in more detail, not particularly in depth, but describe your education as it pertains to this field?
Sure. I graduated from North Miami Beach Senior High School in Dade County, and then I went to Harvard College, Cambridge, Massachusetts, graduating in 1978 with a bachelor's degree in biology. I then went back to my home state of Florida and went to the University of Miami School of Medicine, and I got my MD in 1982. I then went to St. Louis, Missouri, to the Washington University School of Medicine, and I did my internship and residency in psychiatry. You can think of internship and residency as an apprentice for young doctors. You come out of medical school, you have an MD, but you need several years additional training, usually in a university setting. So after finishing my residency, I spent 1 year on the faculty at Washington University, and then once again came back to my home state of Florida. And I've been in Central Florida since 1987, practicing in the Orlando area. And in addition, I have a number of board certifications. So I am board certified in psychiatry, addiction psychiatry, geriatric psychiatry, and forensic psychiatry.
And Dr. Danzinger, have you ever testified in court before?
Yes, I have.
And how many times have you done that?
Over the past 30 years, many times, 600, 700, a very large number over 30 years.
Okay. And have you testified in death penalty cases?
Yes.
And with regard to your testimony in death penalty cases, have you testified for both the state and the defense?
Over the years, it's been about 50-50. So some of them have been at the trial level, such as today. Sometimes they come back on appeal, and there's more courtroom testimony. So I've been involved at both the trial level and on the appeals, which may take place years later. And it's been about 50-50 over the years, either on the defense side or on the prosecution side.
Death penalty cases?
Yes, on death penalty cases.
And what about just in criminal cases in general?
Well, in criminal cases, I'm often appointed by a judge, and I may be asked to do competency, which is what's their mental state today? Are they mentally able to understand what's going on with the case and work with their lawyer? Or I may be asked to testify as to their sanity or mental state at the time, or sometimes even mitigation reasons that the court might choose to treat someone with some leniency or give them a lesser sentence. So in many cases, it's the judge who appoints me, so my opinion falls where it may. I'm also often retained by defense attorneys, sometimes the public defender's office, sometimes private attorneys, and less often, but occasionally, by the state attorney's office, such as I'm doing today. So probably 50% court appointed, 40-45% a defense attorney retains me, and probably around 5% is the state that actually retains me.
Okay. So out of the times you testified, only 5% of the time you're testifying on behalf of the state?
Well, not quite, because, and it's complicated, but when I do a court-ordered opinion, sometimes my opinion favors the state, and then the state asks me to come testify. So I was originally retained by the state. The judge asked me to see someone. My opinion favored the state, and then the state calls me as a witness. So my actual testimony is more 50-50.
And I want to talk to you about this particular case. Were you asked, Dr. Danzinger, to review materials regarding the defendant's state of mind at the time that the crimes were committed, in this case on August the 27th of 2015?
Yes, I was.
And do you recall approximately when you were asked to do that?
Sure. I first spoke with Ms. Dunn around June 14, just last month. And after figuring out whether I had enough time to do this case on June 19, you all formally retained me to get involved in this case. So just 5 weeks ago, basically.
And just to kind of talk about some of the materials that you received. You received a number of, and I will just kind of go through some of them, kind of highlight some of them. You received some transcripts of interviews and depositions of various individuals involved in the case?
Yes, I did.
Did you receive medical records of the defendant?
Yes, there were medical records from different sources, but yes.
And pharmacy records of the defendant?
Yes.
Did you receive a recording, both audio or a video recording of a proceeding, a court proceeding that the defendant attended on August the 27th, 2015?
Yes, the audio recording, not the video.
You received a lot of other materials that you reviewed in consideration of any opinion that you might develop in this particular case, correct?
Yes.
and some of those may come up later on as we kind of go through your testimony. Did your work on the case also involve conducting an in-person, face-to-face evaluation of the defendant?
It did.
Okay, and where did that face-to-face evaluation occur?
It took place essentially across the street at the St. Johns County Jail here on Lewis Speedway Road.
And when did that occur?
On June 24, 2018, about a month ago, at 10 o'clock in the morning.
And approximately how long did you spend with the defendant?
It began at 10 o'clock and ended at 1:20, so there were a few bathroom breaks and the like, but 3¼ hours, more or less.
Okay. Did you also, during the course of today's proceeding, were you also able to listen to the testimony from Dr. Daniel Buffington?
I was.
After reviewing all these materials that you received, after conducting your extensive evaluation of the defendant, after hearing and listening to Dr. Buffington's testimony, I'll just sort of start with what your opinion is, and then we'll kind of work back from there. Were you able to develop an opinion about the defendant's state of mind, specifically as it relates to the issue of impairment, on the approximately 10:30 a.m. on the morning of August the 27th of 2015?
I do have such an opinion.
And what is that opinion, sir?
It is my opinion that Mr. Colley was not impaired by substances at approximately 10:30 in the morning on August 25, and he was not suffering from any parasomnia or disorder of sleep.
Okay. And I think you said August the 25th. Did you mean August the 27th?
I'm sorry, August 27, 2015.
Thank you, sir. And can you just walk through, Dr. Danzinger, the basis for your opinion? What was it that you reviewed in the records that you received, information that you obtained from the defendant himself that led you to that opinion?
There were several factors that were important for me. The first was his behavior in the days and weeks before the events of August 27th. And we know that he was working. He was working as a mortgage auditor. He was going to work every day, taking care of the children. We even saw photographs this morning of just a day or two before where he's coaching t-ball, where he's at a birthday party for his son. So even though he was on some antidepressant medications, there's nothing to indicate that his behavior was altered, peculiar, or acting oddly. In the days before, he apparently was acting normally, taking care of kids, going to work, going to birthday parties and recreational events.
And let me stop you there, Dr. Danzinger. What is your understanding of when he was last prescribed some of the medications such as the Ambien, the Wellbutrin, the Cymbalta, that is really kind of the focus of everyone's attention here?
That would have been on August 10 when he saw his primary care physician, Dr. Sanchez, so 17 days before the murders of the two women.
Okay. And your testimony is that that from the time that he was prescribed those substances to the day of the homicide, there was no indication that he had any issues with these medications, correct?
Correct. And while theoretically these medications, which I frequently and often prescribe in my practice to my own patients, while there are side effects you can read about in a textbook that occur, most of these are rare and uncommon. So as I look at were there any peculiarities in his behavior, impairing him from going to work, taking care of kids, coaching, enjoying a birthday party, nothing in that 17-day time frame that these antidepressant medications or coming off medications had any peculiar or bizarre effects on his mental state. It just wasn't there.
Let me talk a little bit about Dr. Buffington's testimony concerning the common side effects or some of the side effects that could occur taking any of these medications. Can you talk to us a little bit about how often or frequent it is that you would actually have all of the side effects that he was talking about versus some of the side effects, and how that sort of works in the research and things of that nature?
Well, one of these things that, as a doctor, I look at prescribing someone Wellbutrin or Cymbalta, the medications that were given to Mr. Colley, or any of these psychiatric medications. Some of the side effects are fairly common. They may occur 5 or 10% of the time. Others are extremely rare and uncommon, less than 1%, maybe less than 1 in 1,000, or maybe only 1 or 2 reports in the whole country. So, for example, if someone's on Cymbalta, well, what may occur more than 5% of the time? Well, someone might have a little nausea or a dry mouth or a little constipation. Usually those side effects dissipate over time. But if they're very problematic, I might need to switch them. But much less common are things like inability to urinate or extreme confusion or abnormal bleeding problems. Those are very rare, but they don't occur often, much less than 1%. So when you look at potential side effects of the medicine, some are pretty common, and I tell patients you might have this, and it's something that occurs 10 or 15% of the time. Others are extremely rare. Nobody's going to get all the side effects that are listed, and the more severe ones are generally rare and uncommon.
Can you talk to us a little bit about what we talked about, sort of Ambien? That was one of the medications at issue here. And we've heard a lot of testimony about the parasomnic effect that sometimes Ambien may have on folks. Can you talk to us a little bit about that, what that looks like, sort of the behaviors that you would see typically when someone's in that type of that state? Can you talk to us a little bit about that?
Sure. And a parasomnia simply means some abnormal event or experience during sleep. So it might be, for a good example, would be sleepwalking. That's a parasomnia, something that happens during sleep that's unexpected and shouldn't happen. Now, there are certainly reports that Ambien can cause people to engage in behaviors like eating or sex or driving a car, but generally these behaviors are poorly coordinated and people appear confused to someone else. So by way of example, I've had some Ambien DUI cases. Someone's in their underwear driving 4 miles an hour, weaving down the street. They're stopped by the police, and they're obviously impaired, but when they blow for alcohol, it's triple zeros. But they're obviously impaired, and they wake up in jail later with no memory of how they got there. But they were obviously impaired to a layperson or to a police officer. So the idea that someone could later appear in court and testify relevantly and coherently would not be consistent with an Ambien confusional parasomnia state. It's absolutely inconsistent. So while Ambien can cause these things, you would expect to see someone acting sort of dazed, befuddled, out of sorts. Maybe they're eating, maybe they're driving a car badly, but if you talk to them, they're not right. And that's the distinction here. So while it can cause that effect, it's usually associated with people taking more than the 10 milligram dose. So it's usually associated with higher doses. You tend to see it when they first take Ambien, not down the road, but if they're going to have it, it tends to happen within the first day or first days when they take it. And it's generally associated with higher doses. And again, if they're in one of these Ambien-induced states where they're awake and engaging in what seems like some complex behavior, they are still out of sorts and dazed and confused.
And you said that usually these are the higher doses. In this particular case, what information did you have that you reviewed concerning how much the defendant said he took the morning of August the 27th, 2015?
When I directly spoke with Mr. Colley on June 24th, he told me that he had 10 milligram tablets and he took 2 halves. So that would be 2 times 5 milligrams or 10 milligrams. And the dose is either 5 or 10 milligrams. That's the standard dose is recommended. So he did not tell me that he took more than he was prescribed. His doctor told him to take either half or whole. He took a whole.
And your testimony, as I understand it, is it correct that to see this type of behavior is if you're taking more than that recommended dosage?
Well, typically it's more common at higher doses. And to be fair, it can happen at 10 milligrams, but you're more likely to see it at extreme effects at higher doses. But still, you would expect if you talked to someone or saw someone at that time, they might be dressed oddly, acting oddly, seemingly dazed, not fully coherent or fully witted. They would not be able to engage in very complex discussions, such as behaving themselves and acting appropriately in a courtroom.
What about making decisions? First let's talk about, you mentioned a court. You were able to review an audio recording of a proceeding that the defendant attended on the morning of August the 27th of 2015, correct?
Correct.
And can you tell us, what you heard in that courtroom proceeding and how it relates to your opinion in this particular case that the defendant was not impaired at the time this crime was committed?
Several things were relevant. First off, this was, of course, time-wise between when he reported taking the Ambien and the 10:30 murders. So it was closer in time to the taking of the Ambien. If there was going to be an Ambien effect, you would expect to see it at 9:30 if it was going to be there at 10:30. So it was closer in time to when he supposedly took the medicine. As I listened, he was sworn in. He answered questions appropriately: name, occupation, education, that he was not psychiatrically ill and not intoxicated. And as I listened to that, he responded to questions coherently, logically, appropriately. The judge went through the plea colloquy, which is, this is what we're doing today. You understand, basically, you understand what's going on. Are you happy with your lawyer, and so forth. He answered all those questions appropriately, and the plea was accepted. After the plea, Mr. Colley said some interesting things that suggest he was mentally intact. He was told he had to attend Bowers' intervention, and he accurately recalled that he'd already signed up, and I believe he had 24 more sessions to go. So he knew that he had signed up and exactly how many sessions were left. He then asked about how his probation could be terminated early. Came up with that on his own. In other words, he was sentenced to a year's probation. What do I have to do to get off it early, which is a reasonable thing to ask. And then, when he was told he had $474 in court costs, he spontaneously came up with the idea, I've already got a $500 bond, can I just apply that to the court costs? And the judge said, that's a good idea, and here's how you can get your change back. So these were all things he came up with on his own that reflect a solid understanding of his position. So he's not just answering questions, this is who I am, this is what I do. He's coming up with these spontaneous things. How can I get off probation early? Hey, can I take my bond money and apply that to the court costs? That suggests he's clear-headed. He's thinking logically. He's coming up with spontaneous things. And these are not overlearned things. Look, all of us have been driving cars since we're 16. We know how to put the keys in and start the ignition. So even in a dazed state, somebody could do that. Maybe they don't drive well, but they could do it. But to come up spontaneously with these ideas, moving the money, how do I get off probation, knowing exactly how many sessions I have left, when you listen to that, this is suggestive of someone who's clear-headed, thinking logically, coherent, appropriate. This is not someone who is dazed and impaired in any sort of sleepwalking state. Everything on that court appearance, to my opinion, as a psychiatrist, is consistent with someone who's logical and clear-headed and not someone who is impaired.
Did you also, Dr. Danzinger, review deposition transcripts from the judge, in that particular case, Judge Charles Tinlin, as well as the defense attorney that represented the defendant that day, Kyle Bedford?
I did.
And did they provide information that you considered and relied upon with regard to their observations of the defendant that particular morning?
I did.
And what information did you have?
The judge in his deposition said he absolutely did not have any concerns about impairment. There were no overt signs, and that he would not have gone through the plea given any concerns that the defendant was not right. Similarly, the defense attorney in his deposition said that Mr. Colley was somewhat nervous, but he did not believe he was impaired, that Mr. Colley understood what I was saying to him, that he responded appropriately, that he understood the plea agreement, and the attorney said, if he didn't, I wouldn't have entered the plea. So both the judge and the lawyer, neither of them had any concerns that Mr. Colley was confused or out of it. Other than some nervousness, nobody had concerns that he was impaired at that moment, which was less than 90 minutes before the murders.
Did you also, Dr. Danzinger, review some evaluations that were conducted by other psychologists or psychiatrists in this particular case that had been hired by the defense?
Yes.
And was one of those individuals a Dr. Harry Kropp?
Yes.
And Dr. Kropp is a psychologist, is that correct?
Yes, he is.
And what specifically did you review as it relates to Dr. Kropp?
Dr. Kropp met with Mr. Colley in November 2015, which was less than 90 days after the shootings. So very close in time, not 3 years late, almost 3 years later like we are now. And what was very relevant to me in Dr. Kropp's report is the sentence where he said Mr. Colley described the events after court, saying he was hungover and just snapped. And what's relevant is there's no mention to memory loss, snapshots, blank periods. It simply said he described the events after court. Now that's different than what was told to Dr. Buffington and what was told to me, but that's very close in time. And one of the points that Dr. Buffington made as I sat in the back of court was that that lack of memory was a factor for him in saying that Mr. Colley was impaired. But we had an interview taken less than 90 days afterwards where Mr. Colley apparently made no mention of lacking memory, can't remember, blanked out, a snapshot. Dr. Kropp wrote, he described the events after court. And Dr. Kropp went on to state that Mr. Colley appreciated the nature, quality, and lawfulness. So the story has changed over time. And if Dr. Kropp's got a full story of what happened, all the events after court, that would indicate intact memory and argue against impairment or confusion due to drugs.
What was your understanding of the purpose of Dr. Kropp's evaluation of the defendant at that time?
To do a forensic evaluation. Was he competent to stand trial? Was he sane at the time? Are there mitigating factors? Just a general assessment shortly in time after the offense.
And when you talk about competency, conducting a competency evaluation, are there specific criteria that a psychologist, a mental health expert, looks at that would be relevant to determining whether or not someone's impaired at the particular point in time that they committed a crime?
Well, yes, and I've probably done 8,000 or 9,000 competency evaluations of my own. And competency to stand trial refers to how is someone today? Do they have a rational and factual understanding of the proceedings against him? And can they consult with their lawyer with a reasonable degree of rational understanding? And then the state of Florida said there's 6 additional things. Does someone know the charges against them? Do they understand the possible penalties? Do they understand the adversary nature of the legal process, meaning who's with them, who's against them, who's neutral? Can they behave themselves in the courtroom? Can they testify relevantly? And then can they relate relevant facts to their attorney? So now if someone has no memory for an offense, that could be a problem in relating facts, and it goes to whether other things can be reconstructed. But as I read Dr. Kropp's report, there was no mention that Mr. Colley lacked the ability to relate relevant facts of what happened to his attorney. That's a key point of competency right in the Florida law. So based on Dr. Kropp's report, there was no reference to snapshots, memory impairment, blackouts, nothing like that, and no mention by Dr. Kropp that there was a concern that the defendant couldn't tell his lawyers about what happened. It's not there November 2015, less than 90 days after the shootings. It's not until years later that we hear, and I heard, I only remember this, it's like a snapshot, and I don't remember things for a while. We didn't start hearing that until more than 2 years after the shootings.
Did you also review some psychological testing that was performed by Dr. Mark Mills?
Yes, I did.
And what was, and I don't know that we, when he testified yesterday, that we heard any information about that. What type of psychological testing did you understand and review that Dr. Mark Mills performed in his evaluation of the defendant?
Dr. Mills did 2 broadband psychological tests. And these are, they can either be done on pencil or paper or on a computer. One of them is the MMPI, or Minnesota Multiphasic Personality Inventory. He gave him the 2nd edition revised form, which is a little shorter. It's 338 true-false questions. And as people answer these questions, it generates a profile. And then that pattern of responses is compared to the thousands of people who took the test before, and it gives you hypotheses that people who answer the questions in this way, this is what they tend to be like. So no testing is 100% accurate, but the test is a very good one. It's been around a long time, and it generates these hypotheses about people's mental state and psychiatric disorders and their personality. It also has internal measures of validity. In other words, it's a cleverly designed test. It can tell you, is someone just Christmas treeing it, just answering it at random? Are they reading the questions? Are they trying to exaggerate symptoms and make themselves look worse? Are they trying to portray themselves as perfect and having no problems? So it not only does it give you ideas about people's mental state, it lets you know if they're answering the test questions consistently and appropriately. He also did a 2nd test, the PAI, the Psychological Assessment Inventory. Again, several hundred questions, and I think you can answer it: agree, partially disagree, disagree. So they cover much of the same ground, and it's a way for someone to take a test. It generates these hypotheses, and then you see, is it consistent with the other information we have? Is it consistent with our interview? And these psychological tests are useful tools. You can either use them in your practice, or they're very helpful in forensic cases or criminal cases. Is someone reporting accurately, or are they exaggerating or minimizing?
And is it correct, Dr. Danzinger, essentially these tests sort of give you an idea of a person's sort of psychological profile, their personality, things of that nature?
It is. And again, I can't just do a test on someone and say, I'm done. You have to look at the psychological test. How does that fit with the face-to-face interview with the person? How does that fit with any medical or mental health records? So it's part of an overall assessment. But with that, yes, it gives you helpful clues about people's psychological state.
And did you go through that process that you just talked about? Did you review that information, the results of those 2 psychological tests, as well as kind of compare that to your own evaluation of the defendant when you met with him?
Yes.
Okay. And can you tell us, were there anything in particular about either one of these tests, either the MMPI or the PAI, that you thought was relevant to this question of what was going on in the defendant's mind? What was his state of mind at the time that he committed these crimes?
Judge, I'm going to object at this time. The testing that occurred this year has no relevance as to the issue that's at hand and pertaining to this witness, so we object on relevance grounds to the issue of impairment overall.
The PAI picked up the alcohol history. He acknowledged problems with the use of alcohol. He acknowledged environmental stress, not surprising in 2017, being incarcerated. Some depression and difficulties in controlling anger. So the diagnoses, the hypothetical or hypotheses diagnoses on PAI or alcohol dependence and personality disorder. On the second edition revised MMPI, the emotional findings included anger, ideas of persecution, and substance abuse. And the testing was suggestive of a person who was anger-prone, irritable, and had low frustration tolerance, and also had persecutory thoughts of others. So the suggested diagnosis was an anger-related disorder, substance abuse problems, and persecutory ideas. Again, this was all from the testing done by another doctor, not by me, but I looked at the raw data and the test results.
And I want to talk very generally about this, Dr. Danzinger, but was there other information that you reviewed and considered with regard to other instances of violence on the part of the defendant?
Judge, we maintain our objection previously stated on the record on this issue.
Yes.
And let's just kind of walk through it. How many instances of violence, with regard to the information that you received and reviewed, how many instances of violence did you look at?
Judge, we object based on the court's ruling. This is inadmissible.
I'll sustain that objection.
Were there instances of violence that you reviewed?
Yes.
Okay. And can you tell us the dates that these occurred?
Objection for the same grounds. He's getting in the back door.
Was there other information that you reviewed, Dr. Danzinger, that indicated that at the time that the defendant committed these crimes, that he actually knew what he was doing? That this was sort of a rational decision that he was making?
Yes.
Okay, and can you tell us about that?
We know that immediately after he fled the scene, which would be suggestive of someone trying to avoid being apprehended, that statements were made, "I'm not going to prison." This is suggestive of a knowledge that what he had done, that he had committed a crime, that he was at risk of going to prison, and fleeing the scene to avoid apprehension, and being captured. And I understand ultimately he was captured later that day in Northern Virginia, several states away. We know that morning a testimony already came out that he had ransacked the house and damaged television sets. So there was aggressive behavior to property just half a dozen hours before the shooting. And that, of course, is a factor for being in an agitated, aggressive state to property, at least. So all of those factors, as well as his ability to be armed and have firearms with him to commit the murders, all of this is worrisome behavior and suggestive of someone who's behaving purposefully and then aware of the wrongfulness of his conduct.
Let's kind of walk through your evaluation of the defendant. He kind of walked you through sort of a storyline of kind of what occurred this day, correct?
Yes.
And I know we already talked about some of the things, particularly the court, being in court and things like that. Can you just kind of walk us through and what did the defendant tell you concerning his actions, starting, say, the night before and all the way through when he basically fled the area to Virginia?
Sure. I'm going to go off my notes, if that's all right.
Yes, sir.
He said that the day before he went to work, it was a normal work day, a solid day, 8:30 to 5, no issues at work, left work 5:30. Mother and father picked up Trey, his son, it was his birthday. We went home. Mother and father took him, we're hanging out on the porch. I tried to call Amanda, she did not answer. She texted, she wasn't feeling well, she was sick, and said, tell Trey I love him. I thought it odd, but I bathed and put the kids to bed about 9:30. I asked him if he took any medications, maybe a Lorcet, one of the pain pills, a few hours earlier. He said, I'm having a drink of Crown Royal, 2.5 ounces of stiff drink. His friend Daryl called, he's at the bar. I go to the bar, mother and father with the kids. I meet Daryl. We have a few more drinks. I'm drinking socially, 4 to 6 more drinks. Left the bar about 2 a.m., bar closed. Driving home without incident, don't get pulled over. He then said also did a line of cocaine, maybe one at 12:30 in the morning, maybe one at 2 a.m. Last drink was just before 2 a.m., closing time at the bar. Drove Daryl home, had one drink at his house, was going to drive to Rhonda's, his sister's house where he was living, but didn't make it to Rhonda's. I went by the marital home to check on her, Amanda. She had said she was sick and thinking maybe we'll have sex. I get to the marital home, I use the garage door opener and my key because I'm able to come and go freely. No one is there, her car is gone, her dog is not there. He wonders, did she go to the hospital, but the dog isn't there, so he thinks something's up. I look around, the bed is made, and he found a box of S&M sex gadgets, saying we'd never done anything like that before, and 2 men's polo shirts that were not his size and not his logo. He said he's intoxicated and upset and broke the television sets. He then drove over to where he was living and went to see his friend Mike Dickens, who he said was 4 houses down across the street. And he showed Mr. Dickens the gadgets and told Mr. Dickens, I'm not crazy, she's having an affair. Mr. Dickens told him to go home, so he went back to Rhonda's house where he was living. I called my wife on the way, told her I was at home now, what I found. She said it wasn't what it seemed. He apologized for breaking the televisions. He's back at Rhonda's house where he's been living. He knows he has court at 9 in the morning. It's close to 6 o'clock. He took a whole pill, which was 2 halves of the Ambien for 10 milligrams total, slept for about 2 hours, and his father woke him up at 8 a.m.
Let me stop you there because I want to ask some questions about the Ambien. Can you tell us, Dr. Danzinger, what is the recommended time that you would take something like Ambien? What's its purpose? What would be the recommended time? And then I'll ask some follow-up questions from there.
Sure. Ambien is a sleeping pill, and its general use is to put people to sleep. The immediate release Ambien is best at putting people to sleep if you have what we call initial insomnia. You can't fall asleep. It has a short duration of action. It has a short half-life, about 2 to 3 hours, and it's not all that effective after about 3 hours or so. Now, there's an extended release or time release Ambien called Ambien CR, which if people who have trouble staying asleep, they may take that because it releases some of it immediately and then it's time release. It releases some of it throughout the night. But he took the immediate release Ambien, which is basically designed to help put someone to sleep. That's its best purpose. And it generally acts quickly within about 15 minutes when it works. So usually we tell people take it when you're expecting to get a decent night's sleep. I would admit I wouldn't tell someone to take it if they had to be up in 2 hours. I would admit that. So generally we tell people to take it if they're going to get a full night's sleep. And what I tell my patients is don't take an Ambien and then say, let me run to the 7-Eleven to pick up some milk. And I also warn them, if they're smokers, don't take an Ambien and smoke a cigarette. I don't want you passing out and setting the house on fire. So I warn my patients if they're smokers and they're on Ambien. So generally it's short acting to put people to sleep.
So it would be something that you would take if you knew that you had, you could get a full night's sleep, right?
Yes, and sometimes what I tell folks is, it's best if you don't take it every single night, because then it tends to lose its effect over time, and when you try to get off it, you may have trouble. So I'll tell people to take it occasionally or intermittently, or if they're lying in bed 20, 30 minutes and they're staring at the ceiling, okay, then go ahead and take it. So I try to encourage them not to take it every single night, but sparingly and occasionally.
So he told you that he went home and took 2 half tabs of Ambien?
Yes, that was his self-report.
Okay, and at what time did you say?
About 6 a.m. was what he told me.
Okay. And so he goes to sleep, and how long did he say he slept for?
He said that his father woke him up at about 8 a.m. These are approximate times.
Okay. And what did he tell you happened from that point forward?
He said that his father took the truck because it had the car seats for the kids.
Just 1 second. There was a question I forgot to ask you. Pardon me. I want to go back to his father waking him up. Did he say how his father woke him up?
He didn't describe that to me other than father woke me up.
Okay.
He didn't expound on that.
Okay. I interrupted you, so go ahead. And what happened from that point forward?
Okay. He said that father took the truck because his truck had the car seats for the kids, so he took his sister Rhonda's car. Now, he said he doesn't recall driving to court, and he said he was told later he hit a mailbox on the way that he doesn't recall it. He said that he took his morning medications, which was Flexeril, the Lorcet, ibuprofen, duloxetine, and left the house about 8:30. He also took some nutritional supplements. I asked him if he remembered court. He says he has a few memories. There are what he described as moments of clarity, a few seconds to minutes. He said they're brief clips, not still images. He remembered his lawyer saying he needed a form, and his father came in with a form. He remembered the judge ruling favorably, and his next clip was he's hugging his lawyer in the courtroom, and it's about 9:30. He then recalled his talking face-to-face with his father, but doesn't recall the conversation. He's in the parking lot outside the courthouse with his attorney, and he remembered leaving the St. John's Courthouse on Lewis Speedway. He told me then he recalls remembering I have to change, I have to get my work clothing, my badge, my gym clothes for a lunchtime workout.
So let me stop you there. So he told you that he was not, when he went to court, he was not dressed for work?
That's what he told me.
Okay, all right, go ahead.
So he needs to get his work clothes, his lunchtime workout clothes, a bag lunch. So he planned to go over to Rhonda's house where he'd been living, but he said he doesn't recall driving over there. And he got home to Rhonda's. He remembered speaking to Amanda on the phone. His recollection is it's 15 or 16 minutes, but he's not sure. She told him he was overacting. He said he was still going to move forward with the divorce. Her reply was, "Give me time, don't do that." And his recollection is that she said, if you stop the divorce, put it on hold, I'll move out, you can have the kids full time at the home. That's what he remembered hearing from Amanda.
Was there any, did he mention anything to you in that conversation about the police being called to the home in relation to him breaking in the night before or anything like that?
Not till the second phone call.
Okay, was that what you were going to next?
Yes.
Okay, go ahead.
He then said there was another phone call at around 10 a.m. Again, these times are approximate. And she, being Amanda, said the police are here. he wanted to clean this up and make it better. And this is what Mr. Colley said. I asked her not to tell the policeman about the television. She said, I won't. He said, Mr. Colley said, I thought you said you weren't going to call the cops. I'll pay for it. Her reply was, I didn't call them. And she said, I'm trying to fix this, James, and hang up. So what she said was, told him the police were here, and we know it was a public safety officer. He says to her, I thought you said you were going to call the cops. And her reply was, I didn't. Which is true. She was not the one who called them. And she said she's trying to fix it.
Okay. And what the next part of his story to you?
His recollection to me was, I start panicking. The cops are going to arrest me. I've got to run over there and give a check to cover the damage. And I asked him how far it was. He said it's 7 or 8 miles. He said he had little memory to drive over. He got there and called parking behind the house on the street behind it in case the cops showed up. So he remembers getting out of the car. He said he was not armed. He said there's a little hill between the yards. He's coming from the street behind it. And he said there's a jogging trail behind the house. And he can see into his house. He's looking into the rear of the home through a sliding glass door. And he sees what he thinks is his wife, and behind her he sees what looks like a man. He remembers not being able to breathe and seeing a man. I saw little black specks. I was lightheaded and I felt faint. I bent over and felt nauseated. And he said, it hit me, don't faint here and have the man find me. He felt that he needed to go. His memories are spotty, but he remembered walking on the little hill and dry heaving. And he then says he has no memory until he's behind the house on a jog trail armed with 2 semi-automatic handguns.
Did he talk to you about going back to the car?
He did not. When he spoke with me, he did not have a memory of going to the car. He said, the last thing I remembered, I'm walking back, I'm dry heaving. The next thing I remember, I'm on the jogging trail and I've got 2 semi-automatic handguns.
All right, go ahead, doctor.
I asked him his next memory. I see through the picture window. I remember shooting at the picture window on the right side of the window, knowing they are to the left. He doesn't remember saying or yelling anything. He remembers running to the window. He said his next memory, I'm in the bathroom, I've got the gun in hand, I'm screaming, my ears are ringing. He remembers saying, where is he? He said his wife is looking at him, she's screaming, he's not here. He says, I saw him, I think he's in the closet. And she says, put it down and give me that, holding out her hand. He remembers trying to get in the closet. And then he remembers going in the closet and it's dead calm and quiet. He then says there's a blank period. He's walking across the backyard, gun in hand. He says to himself, pardon my language, oh shit. I asked him, did you have any memory of shooting anyone? He said no. He said, I assumed I shot Amanda. I didn't think or know I shot anyone else. He doesn't recall driving away. He said his next memory is he's back in Rhonda's area. He heard on breaking news 2 women were shot in the Maribel neighborhood, and he remembered feeling scared. He does not remember a phone call with his father. He stops by Rhonda's house and he grabbed an AR-15 rifle. Then there's a period of blank. He said, I remember my father screaming at me what happened. Mr. Colley said, I'm putting the rifle in my car. My father's asking me what happened. I told my father, I think I shot Amanda and her friend. The father said, get out of here, son, we'll work this out. He gives me money, go to Donna's in West Virginia. He said the blackouts grow longer. I don't remember driving up there. There's flashes of being pulled over for erratic driving. And then he summarized it later saying, I went over there to pay for the TV. I had my checkbook at the house, assuming the marital home. I saw a man there. I assumed it was her lover. I felt a panicky attack. I don't recall anger, instead scared. I was angry when I was looking for him. I don't remember crossing the yard except for a split second. I don't remember yelling from the yard. He said, I just don't know. It's not clear. It's choppy. It's all I have.
Obviously, his self-report, doctor, is different than the opinion that you have testified to today, correct?
Correct.
And how do you reconcile the statements that he made to you during your evaluation and the different opinion that you reached in this case?
Several factors. First, Dr. Kropp said he told me what happened after court. 10 weeks after the offense, November 2015, no references to choppy memories, still pictures, video clips, long periods of blackout. It's not there. And then we have something here that's very unusual in a case like this. Less than 90 minutes before the murders, he's in court where there's an audio and video. So we know what his mental state was like 60 to 90 minutes before the shooting and closer in time to any drug effects. If someone was under the effect of a drug, you'd expect to see it closer in time, not after the fact, especially a short-acting, immediately dissolving drug. And what do we have in court? It's perfectly coherent, logical, rational. Judge doesn't have concerns. His own defense lawyer doesn't have concerns. He comes up with these spontaneous ideas about taking the bond money. How can I get my probation terminated early? He knows exactly how much he has to go with the batterer's intervention. He's clear, coherent, and logical. So trying to say that 60 to 90 minutes after that there's some drug effect, it doesn't make sense.
Everyone, sure. No further questions. Mr. Wood, how long do you anticipate your cross-examination?
Maybe a little bit. I don't know if that makes a difference.
Yes, let's go take our mid-afternoon break at this point, folks, before we get into cross-examination. So Dr. Danzinger, it's almost 2:30, so let's plan on being back and ready to come back at 2:45. And again, don't discuss the case among yourselves or with anybody else during the break until you research and leave your notes here in the courtroom. 2:45, be back in the jury. Everybody else remains. All right, y'all can be seated and remain in the courtroom until you hear us out of the hallway. Dr. Danzinger, you remain on the witness stand, so don't talk with anybody during the break. Just free to go out and whatever during the break. Just don't talk with any of the lawyers or anybody else for that matter during the break. Of course. And this will give the state an opportunity to check on Judge Timlin, see what his status is. Communicate as he calendar, and we'll check on that. All right, we'll be at recess until 2:45.